everyone. On behalf of Chairperson Uma Chigurupati and her committee, I, Honorary Secretary Flo, Radhika Agarwal, extend a warm welcome to our esteemed guest speakers, Mr. Pavan Kumar and Ms. Manasi Chaudari, respected past chairs, members, old and new, to Flo Hyderabad session on inheritance laws, rights, responsibilities, and legalities. Divide equally, gender be gone. This landmark judgment on women's inheritance rights by the Supreme Court has paved its way to newspapers' headlines 3 days back, comes as an appeaser to women, re-emphasizing the saying, once a daughter, always a daughter. A country where women face massive social and legal hurdles to inheritance and are incarcerated by social norms, this is a big win. At the right time that the society takes a turn from the patriarchal mindset and sees daughters and sons equally in terms of inheritance. Though most of the women today are financially independent, they are not aware of their rights in ancestral property. How can women claim these rights? How tough is the legal battle? Women, irrespective of class and education, have many doubts that need to be cleared. To clarify these doubts, we have amidst us Mr. Pavan Kumar from the Law Chambers and Ms. Manasi Chaudari from Pink Legal. Let us start this evening by salutation to our national flag. Now, I would like to invite Chairperson Uma Chigurupati to give her welcome address.
Thank you, Radhika. Good afternoon and a warm welcome to one and all. A hearty welcome to Mr. Pavan Kumar and Ms. Manasi Chaudari. Indian women, irrespective of class and education, have many doubts regarding the inheritance laws and need to know her rights in this subject. This need to be addressed, clarified, and cleared. I thank Mr. Pavan and Ms. Manasi for accepting our invite and being with us today to take us through this important topic. I will quickly go through the programs conducted in the last fortnight at our chapter. A learning session with Shreya Bajaj on photo editing on smartphones was organized on the 21st of January, which attracted a lot of participation. This session was very engaging with a lot of learning and take home for the members. Under our fitness initiative, which was titled as Feet on Fire, an energizing yoga session was organized with our own member and yoga instructor, Bela Modi. With her spontaneity and enthusiasm, Bela made the session very interesting. This is our 10th version of our fitness program. As a part of our outreach initiative, a workshop on first aid was conducted for college students. Mr. Karthik from Alert Foundation explained in detail how one should be a first responder in case of health emergency. On the 26th of January, the day our country is celebrating the Republic Day, we from our chapter has released a video on handlooms, showcasing some wonderful views of Telangana and Andhra Pradesh, urging and requesting all to wear, gift, and promote handlooms, which are integral part of our rural economy and culture.
प्यार से बनाते हैं हम लोग ये साड़ी। आप भी पहन लीजिए प्यार से ये साड़ी, दिल से पहन कर देखिए आप खरीद कर, आपको कैसा लगेगा आप बोलिए।
Namaste, I'm Uma Chigurupati, Chairperson Fiki Flow, Hyderabad. Handlooms are one of the richest cultures of our country, and it is also one of the oldest traditions of our country. Let us support the weavers by wearing, gifting, buying and promoting handlooms. Namaste.
Once again, I request you all to wear and promote handlooms. It's our responsibility to uphold this great tradition and help the artisans and the handloom weavers to have a better livelihood and dignity, and make sure the next generations take it forward with pride. Thank you so much. Namaste. Over to you, Radhika.
Thank you, Uma. I'd like to invite Learning Modules Head Pooja Mitra to introduce our panelist, Mr. Pavan Kumar.
A double gold medalist from Nalsar, youngest partner at a national law firm at 30, and now a founder of his own firm, the Law Chambers. Pavan has worked with several Indian corporates and promoters in their transactions with banks, funds, financial institutions on a broad range of matters. He has also worked in the context of both inbound and outbound investments, strategic and financial, mergers and joint ventures. Pavan also advises on a variety of corporate commercial disputes, shareholder disputes, mergers, demergers, and amalgamation of companies, and regular advising clients on dispute resolution strategies, including that appears before trial courts, tribunals, and high courts. Pavan has serviced clients across various sectors, such as healthcare, IT, media and entertainment, pharma, and real estate. His clientele include sports and movie celebrities such as Gopi Chand, PV Sindhu, VVS Lakshman, Pragyan Oja, all of them who reach out to him as their trusted legal advisor. The most recent case that he's been dealing with is being the drug case in Hyderabad, where just yesterday he secured bail for those accused on the crime. Welcome, Pavan. Over to you, Radhika.
Thank you. Thank you, Pooja. Now, I'd like to introduce our next panelist, Ms. Manasi Chaudari. Manasi Chaudari is a business and transactional lawyer who is passionate about women's rights. She is the founder and CEO of the award-winning and India's only legal platform for women, Pink Legal. In 2018, Manasi assisted Justice Chandrachud in the Supreme Court of India on the landmark cases of Section 377 and entry of women in the Sabrimala temple. She was awarded the Legal Entrepreneur of the Year 2020 by Business World and the Digital Women 2020 Award by She TV, The People and Google. Manasi has also been featured on several platforms, including NDTV, The Quint, Livewire, and Tweet India. She has also conducted talks for global companies like Puma, Instagram, and Tinder. Currently, Along with her professional practice and Pink Legal, Manasi serves on the Sexual Harassment Committee of Tinder India. Now, I would like to invite Chairperson Umachi Gurupati to take the session forward with our esteemed panelists. And members, don't forget to post your questions in the chat box. We will take them at the end of the session.
Thank you, Radhika. Once again, thank you very much, Mr. Pavan and Manasi, for being with us today. Knowing about inheritance laws, the rights, responsibilities, and the legalities is necessary for every citizen, especially for a woman in our country. It is a common notion amongst most that a fancy marriage and sovereigns of gold are what a daughter can expect at best. When the marriage doesn't work, other women go through various kinds of financial difficulties and burdens. She opens her eyes. It is very important and a necessity to make more women aware of their rights in inheritance. How can women claim these rights? How tough is the legal battle? As I have mentioned earlier, Indian women, irrespective of class and education, have many doubts that need to be cleared. We all are aware that the Supreme Court on the 21st of January conferred daughters with equal right to father's property, even if the father had died intestate, that is without the will. During this verdict, it is also quoted what even in the ancient Manudharma Shastra said, that the son and daughter of a man has equal rights to inherit his property. But how many are aware of it? And what percentage are following this? Not just as daughters, as wife, as mother, and also as sister. Also, many questions like, can a wife expect maintenance from her husband after divorce, even if she is educated or economically independent? Many things to be known and aware of. Mr. Pavan and Manasi, the platform is yours. Please go ahead.
Thank you, Uma. Thank you, Pooja and Radhika. Thank you for this opportunity of being with you. And since this is a women's organization, and I let my woman panelist with me, Manasi, take the lead on this. Manasi, over to you, and I'll step in wherever required.
Thank you, Uma, and thank you, Pooja and Radhika. Thank you, Pooja, for inviting us for this forum, and I'm really grateful. And I hope that we're able to add some value today, and I hope that you all take back something new, that you all understand about your rights related to property. And because actually property rights is a very complex subject, and it is divided according to religion, and it is covered across several laws, we have tried to keep it simple and try to keep the scope a little limited so that we are able to help you understand one part of it properly, instead of being all over the place and kind of leading to more confusion than actually helping you out. So beyond what we have covered today, of course, if you have any questions, then you're most welcome to ask us, and we will be there to answer your queries. Or even if you want to ask us sometime later, that's also completely okay. So we have a small presentation prepared for you all, just to kind of aid us in explaining what we are going to talk about. And I think first Pavan will take over explaining part of it, and then I will join in, and we will just divide it between us, and then we'll move on to the question and answers if you all have any questions.
So while the introductions were going on, I just quickly made note of 2 points. I think when Radhika said it's a patriarchal mindset, and yes, I have no reason to differ with you, Radhika. It's always been, and I think for a foreseeable future, that mindset is something that has to change. And only with that change will the so-called equality, as the Constitution provides for, can actually come in true spirit and implementation. Now, Uma said we want to make women aware of their rights. And I'm not really sure how many men after this are going to be friends with me, but well, that's the nature of the conference and the seminar, so be it. And we just get into the presentations now. Right, so very simply put, the woman and the inheritance, we've put up a small slide, and let me take you through. I think, like we all know, My part of the whole discussion is going to be in terms of historically what it has been. And then we'll jump into the futuristic part about how to secure the inheritance. Now, we are all aware that the Vedas and the Smritis are the basic form from where the Hindu law comes. And they are not codified, they are in whichever form that they are. And then Hindu law has two elements to it. One is the Mitakshara school of law and one is the Dayabhaga school of law. Now, what it is, I really don't need to explain because that will just take us into a whole different realm. But simply to understand Mitakshara, there is a Benares school that deals with the North Indian side, then the Mithila of other side, then the Bombay on the western, and then the Dravidian, like it is the Aryan and the Dravidian. So Dravidian is the south of India. So the different forms of Hindu law that are kind of followed across different parts of our country. Now, apart from these, you have a lot of historic customs, the equity, justice, and conscience, all of which find its place in the cumulative consolidation of Hindu law that kind of come down into the culmination of what the now codified law of Hindu succession is. Now, all of these aspects from the various scriptures have been taken to come out with a compendium or a consolidation, and it's been codified. And that law is what we all are governed by today. Now, when you talk about in a very layman perspective, now there are two concepts of the Hindu succession. One is what's called the joint Hindu family. And now the joint Hindu family is basically one that's very loosely defined to mean a family which is together in worship and together in holding of its assets, which means praying to the same God and then holding on to the same joint family assets for the benefit of the rest of the family. And the people who form a part of the joint Hindu family are all lineal descendants from a common ancestor. And there it includes the wife and the unmarried daughter. And before you're all over the place, guys, let me tell you, none of this that I'm going to say right now matters because the Supreme Court has already said something else, but this is just like a historic relevance. So just bear with me for a minute. So therefore, the lineal descendants from the common ancestors, including the wife and the unmarried daughter, they all form a part of the Hindu family. Now then, what's a Hindu coparcenary? And this is the more important part, because a Hindu coparcenary is a part of the Hindu joint family, right? And a Hindu joint family is not a legal entity, but it's more of a concept. It's a creation of fiction, like all of us living together and then living in the same roof, even if not living under the same roof, but still holding our assets in common under a common business is what a Hindu joint family is. Now, as far as a Hindu coparcenary is concerned, this, on the other hand, is limited to only 3 lineal descendants, which means grandfather, father, and son. And like I'll repeat, grandfather, father, and son. The women do not have a place in this, right? Now, that's exactly why the law had to come. And with effect from 2005, 9th September 2005, the Hindu Succession Act, it was an amendment by which they included daughters into the coparceners definition. Now, like you can see in the slide, it says that a coparcener is someone who gets a right in the property by birth. For whatever reasons best known, and I can't comment on those, a daughter was left out of this definition. So she was never entitled to it. With effect from 9 September, the daughters have been recognized. And what's really interesting is to see the objects, like I've shared it here. Now, what was the purpose for the government or for the lawmakers to bring about an amendment to bring the woman into the scope of a coparcener? Now, if I've just read the highlighted portions, they said that females cannot inherit in ancestral property as their male counterparts do. The law, by excluding the daughters from participating in the coparcenary ownership, not only contributes to her discrimination on the ground of gender, but has also led to oppression and negation of a fundamental right of equality guaranteed by the Constitution. So in 1950, though our Constitution said that we're all equal in the eyes of law, it was not until 2005 that the legislature woke up to this realization that yes, the Constitution says something, whereas the laws with regard to the women's rights, as far as the inheritance is concerned, is completely contrary to that. And therefore, they bring about this amendment. And once this amendment comes, this is what the new Section 6 looks like, which is the the devolution of interest in a co-partner's property. So it basically says, on and with effect from 2005, the daughter of a co-partner by birth becomes a co-partner in a right in a manner as that of the son. And hooray, here we are discussing the rights of women, their inheritance, and what takes on from here. So up until 2020, though this amendment came about in 2005, there were different high courts in different parts of the country interpreting whether Section 6 was retrospective, retroactive, progressive, how was it going to come into play? And then what was the cutoff date? Now, this entire discussion was put to rest now in 2020 when the court finally concluded. A 3-judge bench, the Supreme Court finally said that as of 2005, the deal is done. The law stands amended. The daughters will have a right as a co-partner. However, the critical part is just so as to prevent any miscarriage of justice and to reopen litigation, it said, and if you can read the last line of the slide, it says, nothing in the subsection shall affect or invalidate any disposition or alienation, including any partition or testamentary disposition of property which had taken place before 20th of December 2004. Therefore, that's the cutoff period. So it's not a case where the woman could now go back and reopen the entire claim and say that though I am a legal heir, I am a co-partner, and therefore my rights are recognized, and therefore whatever my father, grandfather, and whoever else did by dispossessing or selling the properties, and therefore I have a share and that sale is invalid. That cannot be done. But all the assets that remain in place as of 21st December 2004 onwards is where the woman can basically make her legitimate legal claim and right over it. And that is the cutoff period. So the subtle distinction is that I have a lot of people reaching out saying that, can I now question my grandfather's alienation? I'm like, yeah, sure. I mean, nothing stops you from questioning it, but is that legally right? Not just legally, but not even ethically and morally in some manners. Well, that's not the scope of the discussion, but nevertheless. So the law as it stands is this. Now, and I know somebody just said a daughter is a daughter, right? In fact, the Supreme Court said this: a son is a son until he gets a wife, and a daughter is a daughter throughout her life. Well, this becomes the basis for now all of us to say that there is no distinction between a son and a daughter, not just with regard to the rights, obligations, but even with regard to inheritance. The question, however, now is a much larger question. And that is, now that we're all entitled to, and we know as a matter of right, that we have a share in the property, what do we do with it? It's one thing to know what I have. It's another thing to know what to do with it. And the larger question is how best to do this. And who better than Manasi to answer these, because she will be the right one to take you through the next parts of what needs to be done. And Manasi, while you start, I myself have a bunch of questions, a ton of questions, in fact. So be prepared to answer those as well, please.
Oh my God, this is like an exam because you didn't tell me about these questions earlier. And I hope to do my best. And for any place where I'm lacking, Pavan is there to always.
I'm sure there are enough lawyers within the organization who can step in. I think Purohita was there. I just kind of saw. She's a lawyer. And anyone else in the group who are lawyers practicing qualified, we can always reach out to them for guidance.
Yeah, there are a few.
There we go. We've got enough support, Manasi.
I know. So I'll just share my screen. So my screen is visible, right?
Yes.
Okay, all right. So yeah, just to, carry forward from what Pavan has told us about how a woman's right to property has evolved under Hindu law, and through, statute as well as through Supreme Court judgments, women are now given an almost equal footing. I would say almost equal and not completely equal, because there is still a lot of scope for improvement, and a lot can be done. But nevertheless, we have made some progress over time. So now let's just quickly maybe sum up and also understand what are the various sources from where a woman can inherit property. So the first one we understood is as a co-partner. which is by birth, you get your share in the joint family property, right? So if any property is joint, for example, to tell you, all of you would have watched K3G. So Amitabh Bachchan and Jaya Bachchan's huge bungalow in which everybody lives according to parampara and according to Amitabh's rules. So that would be a joint family property. But whereas once Shah Rukh Khan moved to London and he had his own house, that would not be joint family property. Okay, so as a co-partner, you can inherit by birth from joint family property, whatever your share is. Then you can also inherit through succession, which is as a class 1 heir. Succession basically means when somebody passes away without a will. Okay, then their property goes on to whoever their heirs are according to law. And the law sets out heirs in terms of priority. So your first priority heirs will be class 1 heirs, then the next one is class 2 heirs and class 3 heirs and so on. And it always goes to the class 1 heirs first. If they are not available, then it will go to class 2 heirs. If they are not there, it will go to class 3 heirs. And usually most people do have some of the other class 1 heir, which is why I won't go into class 2 and class 3 because that will just create confusion. And we'll focus on class 1 heirs for today. So you can inherit as a class 1 heir from your immediate family members. And I will just come to who are you a class 1 heir for, right? So if you are a class 1 heir for somebody, then you can inherit their property. So we'll understand who women are class 1 heirs for. And number 3 is through a will. So through a will, you can inherit from anybody. So if anyone has a great aunt somewhere in Europe who wants to leave you a beach facing bungalow through her will, she she's most welcome to do so, and you can get it from her through the will. So you can inherit anything and from anybody through a will, and there's absolutely no restriction on any relationship, etc. So inheritance through succession, which is the second part which we were talking about, because as a co-partner, we've already understood from what Pavan has explained to us. So as a class 1 heir, so when does this apply? Obviously, when somebody passes away without a will, and their property will get equally divided among all the class 1 heirs. So if there are 4 class 1 heirs, it will be 1/4, 1/4, 1/4, 1/4. If there are 2, it will be half and half. So how many ever class 1 heirs are existent? Okay, and let's see who women are class 1 heirs for. And I have to have a rider over here that this is specifically for Hindu women because it is the Hindu law and succession under Hindu law. And I was telling you at the beginning also, property rights are pretty much religion specific. So we are covering succession for Hindu women over here. So who can a Hindu woman inherit property from through succession? That is, who are you a class 1 heir for? So you can inherit from both your parents. So as a daughter, you are your parents' class 1 heir, both your mother and father. And you will inherit obviously equal to a son. So daughters and sons are on an equal footing. Then you will inherit from your husband, and you can inherit from your son. So as a mother, you can inherit from your son. But if you observe that you cannot inherit from your daughter, okay, so class 1, you cannot inherit from your daughter because a mother is not a class 1 heir for daughters. And this is mostly because under Hindu law, when a daughter is married, it is considered that you have now become a part of another family, which is your matrimonial family. So a woman's class 1 heirs, once she's married, they change and the parents are not included in this list, which is why you cannot inherit from your daughter. But you can inherit from your parents as a daughter, you can inherit from your husband as a wife, and you can inherit from your son as a mother. This is when there is no will, and in case of devolution by succession. So to quickly recap again, as a co-partner, as a class 1 heir, and through a will, you can inherit from all of these 3 sources. And now that you have inherited all this property and accumulated so much property, you would obviously want to know what to do with it and how you can control it, and you can distribute it to whoever you want it to go to. So let us understand how you can plan your property succession. So how do you pass on your property? There are broadly three different ways in which you can do it. One is through a will, which I'm sure most of you will be more or less familiar with, but we'll talk about a few basic aspects of the will for anybody who's not familiar with it. Then through a trust, and through succession, we've just explained how if there's no will or there's no provision, then it goes through succession. So first, coming to will. So what can you pass through a will? You can pass any property which you own or which you have a share. And obviously you cannot pass your neighbor's property and say that in my will, my neighbor's property will go to so-and-so, right? So it has to be something which you own or have a share in. And you can pass it to anybody. So as I was saying, if you want to be that great aunt for someone and pass on your bungalow to an unknown niece, you can also do that and send her, your best wishes. And then how do you make your will? So can it be written or oral? It can be oral. It's not required that your will has to be written. So when somebody maybe, in their dying declaration on the deathbed, they quickly want to say that, oh my God, I didn't distribute my property, so it goes to A, B, and C. That will also be considered their will. But obviously you will need witnesses and it becomes difficult to prove, and there can be a lot of legal mess. So which is why it's always recommended that you go for a written will and also a registered will. So written and registered. Registered means you go to the registrar. So you would have done property transactions, right? So every time you buy or sell a property, you go to a registrar and register that transaction. So similarly for the will, you have to go and register it. And why should you register it? Because it serves as evidence, or it serves as proof that, look, this is my will and this is the latest will. That, so that tomorrow if somebody comes up with another will or says that, no, this is the actual will, that is not. When you have something registered, it can always serve as better evidentiary value compared to just a random document. And then, if possible, get it drafted by a lawyer, because obviously you would want your assets to go without any kind of hassle. So it's not compulsory, but it's just recommended. And how much property can you pass? So under Hindu law, you can pass on your entire property through will. So you can choose to completely give your property to one person, completely eliminate other people from it. So it's up to you. Whatever you want, you can do with your property. But under Muslim law, only 1/3 of the property can be passed through will, and the rest of the property passes according to law and the succession that the law lays down. So to whoever the heirs are. Then to understand on how to create your will. So first, just consolidate all your assets, take stock of all the property that you have, both movable and immovable. So it can be gold, it can be your real estate, it can be anything. So all the assets, it could also be M.F. Hussain paintings or, artifacts, or Uma may have handloom saris, which she wants to pass on. So just take stock of everything, all the assets that you have. Okay, then make a list of all the beneficiaries, that who do you want to pass on which property to, and then divide it. So maybe you want to give all, your gold to XYZ. Maybe you want to give this particular ornament to so-and-so, this painting to so-and-so. So divide your property, then identify the executor. Basically, an executor is somebody who will carry out the will for you, right? They will make sure that whatever is written in the document, your wishes are fulfilled. So identify the executor. We have Pavan over here, who is the executor and can be the executor for everybody's will. So speak to Pavan and then prepare your will deed, which is basically have all of this put down on paper in proper form, draft it, and then get it registered. So these would be roughly the steps and the trajectory you follow to make your will, so that you ensure that you don't miss out on something, or you don't miss out on any beneficiary, and that it is properly and comprehensively put together. And remember that you can always amend your will at a later date. So today you may, write something, but tomorrow you may have a fight with someone and want to remove them from your will. You can always do that, and you can amend your will. And I think we would have seen this in a lot of Bollywood movies also, right? Where somebody or the other is murdered because they wanted to change their will. So be careful if you do choose to do that. Make sure nobody gets to know about your intention. So now coming to trust. So trust is generally, it's not as common as will, maybe in India, not as yet, but it is picking up for sure. And so there are basically 3 parties in a trust. So in a will, we saw there will be, again, in a will, you have the person who is creating the will. Then you have the person who is the beneficiary of the will, who's going to get, the benefits of the will. And thirdly, you have the executor who is basically going to carry out the will for you, right? Similarly, in the trust, you have a settler, which is a person who is making the trust. So, I want to create a trust for my children. So I become the settler. Then you have the beneficiary, is the person who's going to benefit from the trust. It could be your children, it could be anybody. You can have multiple people. And then you have trustees, which is something like an executor for a will. So a trust, but obviously an executor's role is much more limited compared to a trustee, right? Because an executor will do a one-time job of executing that will, but a trust is usually for a prolonged period of time, and it's a regular, work that trustee does. So trustee is the person who will manage the trust, who will make sure that the trust is run according to all the rules, and who's make sure that the trust property goes to whoever it is meant for. Then, how do you create a trust? So first, similar to how you create a will, first you define the property that you want to put into the trust. This is called the trust property. So it can be, again, movable and immovable property. It can be a combination of both. That is up to you, what kind of property you want to create in the trust. Once you identify this property, then you also need to identify what are the goals of your trust. Because a trust is something that is over a prolonged period of time. Will takes place after a person passes away, and then you carry out that person's wishes. But a trust is something that you can put in place even today. And if you want to systematically start putting aside certain amount for a particular reason, you can start making a trust even today, and it can go on for however long that you think that the trust should be running for, right? So which is why defining the goals of the trust is very important. So do you want it to be something like a perpetual trust, where you have, property which you want to be passed on from generation to generation? So you don't want that any particular generation, or maybe your children, take that property and sell it, or whatever it is. You want to make sure that it remains in the family for a long time. So in that case, you can create a perpetual trust where they can enjoy the property, but they will not become the owners of the property. So they won't be able to, dispose it off or sell it. Secondly, you can also create a time-bound trust, which means that maybe after my daughter turns 18, she will get access to this fund, or she will be able to use this. Or maybe when she attains the age of 25, or maybe in so and so year, she's going to get it. So you can create a time-bound trust that after this particular time milestone, this will happen. Or you can create a conditional trust as well, that, okay, you can use this whenever you want, but only for this particular purpose. For example, I'm creating a trust for educational fund, or your college fund. So whenever you want to go to college, or you want to fund your education, you can use the money from the trust. So it can be a condition. So whatever it is that you want the trust to serve. Okay, so you have to define the goals of the trust, and also how the trust property will be distributed between all of them based on your goals. Then number 3 is obviously trust deed. The same way that we had the will deed, we will have a trust deed, except that in the will, it is completely optional, and you can even have an oral will, but a trust has to be written and registered, because it is a very, it is something that the law also looks into and regulates. So it has to run according to whatever is written on the trust deed. So a trust deed is a very important document which will lay down all the rules for administering the trust. And it's something that you have to put in place very carefully, because you can't, it's not very easy to amend it again and again. And, it is something that it has a more of a long-term effect. So have a trust deed carefully drafted and get it registered. So registration is compulsory for a trust, unlike a will. So this is how you create a trust. And then the third way that your property will pass on. So if you have, probably you didn't get the opportunity, or you didn't choose to distribute your property through a will or a trust, then your property, this is in case of Hindu women, a trust and will is religion agnostic. So it can be for a woman of any religion, whereas succession, I'm just covering a Hindu woman's, but obviously a Muslim woman or a Christian woman will have her own succession laws. Okay, so if there is no will, you haven't defined where your property is going to go, then it will go according to succession. And where does a Hindu woman's property go? So who are your class 1 heirs? Your property will go to your class 1 heirs, right? Just like you will inherit from your class 1 heirs. So property passes on to husband, then your son, your daughter. So as a wife, your property will go to your husband. As a mother, your property will go to your children. And if they're not there, then it will go to the heirs of the husband. Okay, but the property does not go to mother, father, siblings. Because as we were discussing earlier, a married woman is considered to be a part of the other family, and therefore her property does not, her parents are not her immediate class 1 heirs. So actually, I have just simplified this, but in actuality, according to law, again, your class 1 heirs for a woman are quite dependent on the type of property as well. So if, and how you acquired that property. So if you acquired the property through a succession from your father, your husband, or your father-in-law, then your heirs are different, but more or less the same, like your husband, your children. And if you acquire the property through any other means is basically not through succession. So it could be through a will, it could be your own property, which you have self-acquired. So in that case, your heirs will be your children. And, you know, there's slight modification, which we don't need to go into right now. And that's something that if you have a specific situation, you can always understand further. But generally, these are a woman's class 1 heirs. So, yeah, I guess that's about it. And I thought maybe I'll quickly cover a little bit of maintenance, though we've not included as a part of the presentation, but because Uma was mentioning it in the introduction. So just to quickly give you a brief, now maintenance can happen in 3 phases, right? One is when you're married. One is in case of a divorce or a separation proceeding, then during the pendency of that proceeding. And then one is after the divorce is completed. And once you are divorced, then it becomes alimony. Okay, so when you are married, generally the law says that it is the husband's duty to maintain his wife and provide her financial support. Okay, and even the Domestic Violence Act recognizes something called financial violence, or which is basically where you don't provide the wife with enough financial support so that she can support herself or for her basic maintenance. And this has been put into law. Obviously, these are laws which don't evolve very quickly, right? So this is there because generally a woman is dependent on her husband to an extent, or to a complete extent, or on a partial extent, which is why the law mandates that the husband should maintain the wife when they are married. Then when it comes to, if you have any, supposing you're going through divorce proceedings. In India, divorce proceedings generally take anywhere between 2 to 3 years, or it can go on even longer, right? So during the proceedings, what is your right? Can you ask for maintenance? Yes, you can. And this is called maintenance pendent right, which basically means that when the proceedings are pending, it is that maintenance that you can ask for. Because in a lot of situations, sometimes, especially a woman who is completely dependent on her husband financially, it can become very difficult for her to support herself if she doesn't have any other means of income, right? So which is why the law prescribes that the husband should maintain her during the pendency of the proceedings as well. And even post the divorce, again, you have maintenance. But the only difference is that when, you can ask for maintenance under different laws. So one is under the Criminal Procedure Code. And in that you can, it's a religion agnostic law where a woman from any religion can ask for maintenance from her husband. But this is only in case when they are, 1 second, I'm just a little confused if you can ask for it when you are married or after. Pavan, would you have an idea about that?
Sorry.
No, section 125.
It's only at the stage of divorce.
At the stage of divorce, right? Yeah. So not when you are married. That's not the regular maintenance. And then you can also ask for it under your religion law. So under the Hindu law, you can ask for maintenance, or whichever religion you fall under. So you can ask for that. But courts have taken quite a varied view. And after divorce, both husband and wife can ask for maintenance from each other. So it is not just the wife who can ask for maintenance. And the court will always look at all the factors and circumstances of both the parties. Supposing the woman is self-sufficient and she does not require any support from the husband, the court may not grant you maintenance at all. Or in case the husband is somebody who does not have a source of income, and the woman has more income, and the court feels that, okay, she is in a position to support him. So then they may reverse order that the woman pays the husband the alimony. So it totally depends on your circumstances and on a case-to-case basis, and there's no specific rules. The court will interpret each case on its own facts about, who will give whom maintenance and what is the quantum of maintenance that will be provided. So that's just a basic brief about maintenance. And I think with that, I'll just conclude and hand over to Pavan. And if you all have any questions, then please feel free to ask us.
So I guess before we take any questions, just a couple of things to say. Now, Manasi has laid out the fact that the succession and planning can happen through the forms of a will as well as a trust. Now, fundamentally, the question that all of us need to understand is, for preparing a will or even a trust for that matter, we need to know what are the assets that belong to the family. And that becomes the biggest challenge for women because of the law of divorce. The reason is that today, when somebody is trying to claim, Manasi, would you like to kind of stop the screen sharing? Sure, thank you. So what happens is, it's one of the biggest challenges in terms of putting together a good will is the fact that men generally do not want to share all details of their business and their assets, because that is exactly what kind of hurts them if in the event of a divorce proceeding. And therefore, the biggest gap to bridge is the bridge of trust. Only when a man and woman are in a position to kind of safely conclude that this marriage is lasting for as long as it will, without there being a separation, will the actual details of all the assets come out. Now, you would have probably seen that there are a lot of wills out there which generally say that I am married to X, I have 2 children from my marriage, and my property will be divided 1/3 amongst each of them. Right? Fantastic. Good job, well done. You've listened to a lawyer, you've written a will, but have you really done good, or have you made it even worse? I mean, I would think it's a very bad way of doing it, because now what you've done is effectively let your children and wife fight over your assets. Now, it's not that a will once prepared automatically comes into force. A will once prepared on the happening of the event has to obviously get into a court of law for it to be probated, right? Now, when you go for a probate, the question is, you got to first kind of say that we are the only surviving legal heirs, and therefore we succeed by way of succession. Separately, you go by way of saying that here is my will, by which I am the beneficiary. I want my 1/3 share. Now, who is this one guy who's actually going to say that you're going to get the bathroom in this Banjara Hills house and the bedroom in the Jubilee Hills house, right? Now, it's the worst form of planning that most men like to do, only because the women are just happy to say, well, my name figures in the document and I have a 1/3 share. You really don't want to kind of go beyond that perspective, right? So the first and foremost thing is to say, I'd rather not have a 1/3 share in something and have 100% share of a lesser value if that gives me more peace of mind, right? That's the first and foremost. Now, second thing is, well, you have a will in place. Now what? You don't really have any liquidity. So again, job well done, but purpose not achieved. Because from the day you demise until the 6-8 months, by the time you actually are able to claim your share of your entitlement, what about your sustenance? How are you actually going to make sure that there is liquidity and funds available to be able to survive? And therefore comes the question of, I have given you access to my bank account and I've given you my FDs, but you've only made me a nominee. What good is that? And nominee versus, again, claiming my right, going behind the banks, asking the bank manager to recognize me as the legal heir. He'll say, go get a succession certificate. That will take a 6 months period. Again, it's a mess. So to simply put it, so therefore, just drafting a will is not sufficient. There needs to be a little more thoughtful process to say that from the date of demise, if the legal process takes about 12 months, in these 12 months, has the family been secured sufficiently for their sustenance? And their sustenance is not going to come on account of being your nominee, making them again dependent on you, but will come from making them independent to be able to lead their lives. And therefore, a will, as good as it can be, you also need to provide for alternate forms of liquidity in the hands of women. Now, what are in the form of a trust versus a will? Now, why would one prefer one over the other? Now, in the case of will, it will only come into force on the occurrence of the event. But in the case of a trust, you're already there in the trust. So let me give you an example of something that we've done recently. There is a running business, a private limited company, very well done. Obviously, on account of taxation and succession planning, we said, because of the dividend distribution, the taxation and everything else is not really helpful. So might as well move the shareholders of the company from individuals into an LLP, right? So we made those two shareholders, who are the husband and wife, form a limited liability partnership firm, and the LLP owned the shares in the company, right? Now, and the LLP was again owned by a trust, where the family is there as the trustees. Now, what happens is, not only do these kind of structures give you the benefit of being able to save tax, but also help you in terms of undivided continuity on the occurrence of an event. Because irrespective of one of the partners' demise, the LLP will continue to be a legal entity and continue to be a shareholder eligible for the benefits. And when dividends are declared, LLP will pass it on to its partners, who are again owned by the trust, and therefore the tax benefits and everything. And I'm not saying this is applicable across everyone. I mean, everybody's succession planning and succession needs are different. But yes, you got to think beyond a will to provide for fungibility of different forms of access. Now, one of the things is creating a life interest. A lot of times what happens is, men being men, they would want to kind of say that, this is my hard-earned money and this is my ancestral property. I'm going to give my wife the right to live as long as she's alive, but it'll eventually go to my son or daughter, as the case may be, right? Now, in that case, what have you actually done? You've made your wife a tenant in your property without any rent, which is good. At least she has a place to live without having to fuss about anything else. But then how is she going to maintain the house? And how is she really going to kind of take care of everything else thereafter? So as much as giving a life interest in the property to give her the comfort and security is essential, it's even more essential to make sure that it continues. Now, let me flip the coin on the other side, right? Now, if some of you actually go back home and now sit with your husbands and partners and start saying, tell me where the assets are. Why are you not going to make me a joint owner in the bank accounts? Now, I need to be in the trust with you. The question is, you may also say, then why don't you as well pass it on to me? Now, well, by all means, some of them would want to kind of do it, but some will say that, hey, what about me then, right? I'm whatever, 40, 50, 60, and I need to have a healthy balance sheet and a bank account so that I can kind of leverage my business needs from providing the assets as a mortgage with the bank for security to fund my capital for my business. So if I'm actually going to pass on everything to my son and daughter and wife and my mother and secure everybody around it, how am I even going to grow my business and in fact help grow the family in terms of its asset and value, right? So there is an interplay. So I do not want any of you to go back and say, you know what, Manasi and Pavan said, no, we have a right in this now, so bloody well give me my share. And they'll come and slap me tomorrow and say that, no, what have you done? You've kind of killed our business, right? So please don't take things out of context here. Well, there is a right and there is an entitlement, but at the same time, it's important. I'm not saying this from the perspective of a man. I'm saying even if it was a woman entrepreneur who's kind of leading her business, even her assets will be succeeded by somebody else. Do not strip the person of their ability to raise the finance and funding to grow the business. Now, nobody can guarantee the success of a business, but the effort that goes towards it, and everybody knows it's all about capital. If you're going to deprive the person of the eligibility of the capital that's available by mortgaging the asset, by succession planning, take it from me, your succession planning is a disaster because you have not succeeded to anything, but you've actually stagnated and you have not let the person or the business grow, nor the asset grow. On the contrary, in terms of certain future events, it will only be a dilution of the asset. Now, this as a whole is what it is. Now, I'm very happy to take any questions. Mansi and I will kind of try and answer if anybody has any specific queries. But yeah, I hope this has been what it is. Yeah.
Yeah, Mr. Pavan, I would be taking those questions from the chat box.
Sure.
So I'll start with the questions. We have one.
I had one thing to ask Pavan, which I think will benefit everybody here as well. That when do you think is the ideal time to start your succession planning? Is there any such time when you should put a mark on it?
So I think the very first time that you make your first penny is when you got to start your planning. Now, what happens is that the only thing that is certain is death, right? And that being the only certainty, everything else, you don't want to leave it to uncertainty. And I know of a lot of friends of mine who with their very first salary, they took an insurance policy and put a nominee, and all of that kind of works as a succession planning in itself. So Mansi, to your question, I think that's what it is. And now actually that makes me think, have I done any of those? Well, I guess not. So time to start.
So you're done with it, Mansi?
And maybe one more, that if supposing my parents choose to leave me out of their succession planning, is there something I can do about it? Can I ask?
Actually, Mansi, that was my question to you. But let me tell you, if my parents choose to leave me out of their succession, well, I've been a really bad son. So, but that apart, what can I do? Well, Mansi, please tell me, how do I secure myself?
I mean, my understanding is that as a co-partner, obviously you have your right to the joint family property. But when it comes to your parents' self-acquired property, which is not joint, then it is completely up to them as to what they wish to do with that property, and they can choose to pass it on through a will to anybody they want to. But in case there is no will, then obviously it'll go through succession, but you can't really force them to give you a share in the property as such.
Absolutely. And I completely agree with you, Mansi. And just going a step further on that, now with the new law with regard to the elderly parents in terms of their maintenance and their right to be maintained by their children. Now, this whole concept of parents in their anxiety to settle the kids, giving the properties ahead of their time in the anticipation that the children will take care of them. Now, you know that the courts have come very clearly on this, and they've said that a gift done by a parent in anticipation of maintenance for the rest of the life, and if the children fail to do so, the gift can be cancelled, right? Now, I've said it in a sentence, but for the court to actually do it is going to take a couple of years, right? So that's what it is. So like Mansi rightly said, I think in the self-acquired versus the joint family, there's a clear distinction. Nobody can exclude you from your joint family property because that, like we said, you get it by way of birth. But self-acquired property, it's my choice. You're nice to me, Pooja, I'll give it to you. If not, sorry. Yeah, Radhika.
Yeah. So we have a question from Amrita Mishra. She wants to know, does a mother have a right to give to sons after father passes away intestate? So in fact, not only sons, does the mother have the right to give to anybody? We would like to know.
So Mansi just clarified that. So what Mansi had said was, in the case of a joint family property, on the demise of the father, the wife, which is the mother, and the children get an equal share, correct? Now, once they get it, now basically it becomes a one-third distribution. Now, the mother's share is then, it's completely her discretion. She can kind of give it to anybody, including to charity, right? So, well, she can gift it and then she can choose to use it for her fancies otherwise as well.
What if assets already sold were registered in others' name?
Then it never gets devolved to start with. Now, let's say that the husband has already sold the asset, and then after his demise, you come to know that you're entitled, but the asset doesn't remain. What the law provides for is devolution of an asset which is unsold, but what has already been disposed, you can't go and then claim, because by that logic, nobody will ever be able to purchase anything, right? Every sale will get challenged on the basis that I have a right in it. And that takes me to a very interesting proposition, which is that when we normally buy properties, what do? as much as we do our diligence and say that, yes, Radhika is the owner of the property, but then I also have a fear. What if Radhika's children tomorrow come and say, hey, you know what? I had a right, which I never signed the document, and therefore today I'm claiming my 1/3 share. So we always insist that the legal heirs of the seller also join the document of sale as either vendors or consenting parties, so that tomorrow you can preempt any third-party claims on the basis of the notion that I had a right. Because the easiest thing to do today in life, I don't think it's making a dosa or an idli, it's about filing a case. Anybody can walk into the court and file a case, and the court will happily take those papers and sit on it for 10 years. But then what happens to the bona fide purchaser for those 10 years, right? So therefore, like I said, the legal heirs, only what is in possession can be inherited, and what is sold cannot be. But a lot of litigation around real estate is purely based on the question that you asked, Radhika.
Amrita Mishra has one more question. How do we find the records of all the assets? Is there a way wherein we can maintain some records, Mr. Pavan?
Manasi, want to answer that?
Oh, I think you are better placed to answer that, Pavan.
Sure. So as far as the land records are concerned, Radhika, what's going to happen is that the sub-registrar of assurances, right? That is the place which is the repository and the depository of all documentation of land purchase and sale. Now, as far as your immovable property is concerned and your movable property, right? Two forms. Movable property in the form of shares will normally be registered with the registrar of companies, and the company in whose shares you've purchased will maintain the register of shareholders. So that's one record where you can find yourself. As far as immovables like land and building, there is a sub-registrar where you can go and find yourself. As far as jewelry is concerned, my understanding has always been that people tend to take their GIC certificates and have a bill, and they actually give it to their auditors for filing their tax returns, and therefore it's there in your balance sheet and audit. Now, if somebody hasn't done all of this for reasons best known, whether in terms of whatever the reasons are, it is very difficult to actually go find it. Now, let me give you an example. Now, let us say that Radhika believes that she has a plot in Jubilee Hills. Now, is she ever going to know how to get it? She will after about 6 months of searching through all the records. But unless you have the details of the plot number, the survey number, at least the person from whom you bought, the year in which you probably have bought, or a property tax receipt, something that has to remotely connect, it's not going to be easy to go and find it. And if you don't even know that, like let's say that if today my wife does not know that there is a property of mine which is situated somewhere, she will never get to know. And which is why I always said, the sharing of information and the fear of sharing is what needs to be bridged. So unless you're able to maintain all record of all the assets at a place where tomorrow on the happening of an event, your partner is able to lay hands on, at least they'll be in a position to from there take it forward to say, how do they claim their right over it?
I would like to ask one question, Radhika, before you go ahead.
Right.
Pavan and Manasi, you are talking about Hindu law. So I know it is applicable for Christian, Sikh and other communities, whereas Muslim law is different. We have quite a few, members who belong to Muslim community also. Can you tell a few, things about what they are supposed to know?
To be very honest, Uma, I think that's an area of specialization which is not even a codified law. And I'm quite sure anything I say, I'm going to be wrong. So I'm sorry, but I will not really be of much help on that subject.
Oh.
I think for Muslim law, it's best that we always speak to a lawyer who is specialized in that subject, because it's very different from Hindu law.
Okay.
And just to clarify, Hindu law doesn't cover Christians. It covers Sikhs, Buddhists, Jains. But Christian law is again completely separate.
Oh, okay.
That's why we didn't go into it, and we only stuck to Hindu law today.
Okay, thank you. Go ahead, Radhika.
Yes. The next question is from Archana Khetan. If the wife is financially better off than her husband, is she liable to pay after divorce?
That's what she
Yeah, I'll just answer that because I was just explaining that sometime back that yes, so divorce, like alimony that you pay is quite gender neutral, and it depends on the circumstances of the husband and wife more than the gender. So if the wife is financially better off, the court may order her to pay alimony instead of asking the husband to pay. And as I was saying, there's no hard and fast rule over here, and it completely depends from case to case on each member's earning capacity, what assets they have, and what responsibilities they have. For example, which parent has child custody and therefore will have to, take care of the educational and other expenses. So it will completely be based on all of these factors. But yes, you may be asked to pay alimony to your husband as well.
Okay. I have a question. There is a popular sentiment in society that since women anyway receive valuable gifts from their parents during festivals, besides their share of dowry, she should not claim property from her paternal home. How does one address this?
I think the law has addressed it by itself. Now, your perception versus what your legal entitlement is already kind of resolved. So, what may be right to some may not be right to the others. But what remains forever is merely because something is given at a time of marriage or something is given at a time of a festival does not deprive you of your entitlement. Now, having said that, you will know, Radhika, that in a couple of communities, there is this concept of the daughters being given their share at the time of marriage. And therefore, the parents do not really provide for them thereafter, and everything belongs to the son. Now, is it right or wrong? I'm not to answer. But the fact remains that do the daughters really get their rightful share at the time of marriage in their hands? Or is it given into the hands of the son-in-law and their family for the benefit of the daughter? Irrespective, the fact remains that her share has been provided in one form or the other. And if she has received that, then, well, the community norms by which they go by would say that everything else remains with the son. And, we've seen a lot of cases where the wills and the succession, therefore, specifically state that I have so many daughters, they have been fully provided for the time of marriage, and they are therefore not entitled to, which also results in a lot of litigation and claims in the future. But, well, those are customary norms at the end of the day.
Yeah, so another question, what about a widow's rights to a deceased husband's property if she remarries? And she has children too from the first husband.
Wow.
You want to answer that, Pavan?
No, pass.
As far as I know, your rights to your deceased husband's property are not affected by, your marital status. So even if you do remarry, because you are inheriting as a class 1 heir. So therefore, that does not make a difference.
So she can get the claim of the property. Thank you.
Pavan, please correct me if I'm wrong.
I may think otherwise, because once divorced, she ceases to be the class 1. And if she is remarried, then she will not have an entitlement. So all that she'll be entitled to will be the maintenance and whatever she gets at the time of her divorce. But, post the divorce, she's not recognized as a wife. Like the other day, I was telling somebody that, I didn't know that a second wife is not recognized as, as entitled to any benefits. And then they said that, oh, that's really bad. But then, the fact remains that what it means is it's not the second wife of a marriage, but once divorced, the second wife becomes the only wife and not the second wife. So I would say, my opinion would be that after a divorce, the divorced woman cannot go back and claim the divorced husband's assets. But
no, I'm not talking about divorce, but I'm talking about a widow getting married, wherein, probably her in-laws are also alive and she's getting remarried.
Oh, yeah. So you're saying about a widow who
Yes.
is entitled to it. Then, yeah, Manasi is correct on that.
So basically, both positions are correct. It's just the circumstances are different. One case she's a widow, and one case she's marrying after divorce.
Thank you, Mr. Pavan and Ms. Manasi, for addressing all our questions and enriching us on our legal rights and responsibilities. Women Power, or Nari Shakti, is truly about changing mindsets, understanding our rights, and welcoming the winds of change. Kumar, would you like to say a few words?
No, it's really wonderful and very enlightening. I think definitely most of our members, before the program has started, there were a lot of questions. I think all those questions were answered. If there is any further questions, please ask. The right people are here to answer all your questions. Thank you so much once again, Pavan and Manasi. It's a very enlightening session. Thank you so much.
Thank you so much for this opportunity, and I hope to be back sometime with another topic with you again.
Yes.
Now, I would like to announce virtual felicitation of esteemed guest speakers. Presentation of Bidri Mementos to Mr. Pavan Kumar and Ms. Manasi Chaudari by Chairperson Uma Chigurupati. Bidri Craft is one of our initiatives for the year.
This will be my first virtual facilitation.
I would now request person, Shubhra Maheshwari, to deliver her vote of thanks.
Good afternoon, everybody. Knowledge is power, and indeed it is true. Awareness and knowledge of certain laws and legalities is imperative as it enables us to reason out in an adverse situation. Especially in countries like India, where there's no uniformity in inheritance laws and the basic framework for inheritance differs based on religion, as rightly pointed out by our speakers today, it is a very, very prudent knowledge that we all need to have regarding the nature of our assets back at home and the liabilities. I, Shubhra Maheshwari, on behalf of Picky Ladies Organization, Hyderabad, would take this opportunity to thank Ms. Manasi Chaudari and Mr. Pavan Kumar for being our guest speakers for the day. We express gratitude to our sponsors who powered this event. Platinum sponsors Greenco, Gold sponsors Granules India, and branding partner RBC. I would also like to thank our IT team for the seamless performance and Flow members, past chairs, team of 21-22 for the continuous support in making this program a success. Dear friends, let's dwell upon the knowledge gained today and make the most out of it to awaken, educate, and empower the women around us. And charity begins at home. Let's first implement whatever we learned today. Stay safe, stay healthy.
Thank you, Shubhra. Mr. Pavan, would you like to say something?
Yeah, I was just looking at the comments, and I think there was someone who said, kindly address my question. Ritu Shah. Is Ritu there? I think she had something specific. Yeah, Ritu, please go on. You're on mute.
Unmute yourself, Ritu. Oh, you're not able to. IT team, could you please facilitate? Yeah, Ritu is asking her question. Go ahead, Ritu.
Yeah, so I was asking, my question was, if it's a second wife and the first wife is deceased and the second wife has children from the first wife and her own children, then how is the property divided?
So you're saying the first wife is deceased and that's a second wife, and there are children from the second marriage as well.
Yes.
They all
and the husband,
yeah,
and the husband is also passed out. Yeah.
Yeah. So as far as the husband's property is concerned, his biological from the first and the biological from the second, they all get recognized as class 1, right? So they're all entitled to an equal share. So the devolution happens accordingly.
Equal shares. So the second wife has her share also then.
Absolutely, because second wife is the only wife now, right? The first wife is no more.
And also the other children from the first wife have their own shares from their mother also then.
They will, yes.
Okay. So that was my question. Thank you.
I think we are done with that.
So I can give a closing.
Yeah.
Mr. Pavan, would you like to say something?
No, I'm good. Thank you. Thank you. I've had a lot of talking to do today.
So much. Shall I give a closing?
Yeah. Please go ahead.
On behalf of Chairperson Uma Chigurupati and her committee, I thank you all for being here. It's your support that keeps us going. It's a matter of immense pleasure and pride to have discussed property, ownership, and inheritance rights of women in India. I am sure each one of us is feeling more empowered. On this note, I would like to end the session wishing you all a happy, healthy, and safe weekend. Thank you and namaste. Thank you so much, Ms. Manasi and Mr. Pavan.
Thank you.
Thank you. Thank you, everyone.
Thank you.